Hi there, my name is Mitchel Roberge. I'm a second-year law student here at the law school. Maine has a rich tradition of outdoorsmanship, including firearm sportsmanship, hunting, sport shooting, and those kinds of sports. This is manifested by Maine having one of the highest rates of firearm ownership in the Northeast, as well as there being hundreds of publicly listed ranges throughout the state. However, it may come to a surprise that in the entire history of the state of Maine, there have been 0 Supreme Court cases dealing with shooting ranges and the liabilities that they have. So what I hope to do is provide a resource for these ranges to know what their liabilities could be. And to do that, I have to look to other states to see how other states are dealing with shooting ranges. The 3 areas that come up most frequently are tort law, legislative solutions, and the Constitution of the United States. The common issues that you'll see are things like noise. Shooting ranges make a lot of noise. Guns are very loud, and some people don't like living next to a range that makes a lot of noise. Additionally, sometimes ranges will have bullets leave the boundaries of the range and end up on abutting property. So the first area is tort law. Now the first 2 torts that come up most frequently are nuisance and negligence. Most frequently they result in an injunction telling the range you cannot function until you solve this issue. A couple examples of where nuisance law has been applied is one case out of Idaho where a range was seeing 1,000 people every year come to their range. This increased to 500,000 people a year, and they were shooting at all times, day and night. It was a lot. And so the court said, this is a nuisance, you're causing problems for the people around you. And so until you can, you have to limit yourself to certain hours, and you can only, the noise has to be contained to 88 decibels. Don't ask me how they did that. A second case comes out of Michigan, where there was a shooting range where they were shooting shotguns up at clay pigeons. This is a sport that they did quite frequently. And these shotgun pellets were ending up on a golf course next door. There have been several golfers that have been hit by a couple of these pellets. It doesn't hurt, they're very small, but nonetheless an issue. And so the court said, yes, this is a problem. You cannot operate until you are able to stop these pellets from landing on abutting property. The other tort is negligence. Now this can apply if a range has done a bad job of constructing their range and for some reason it's unsafe. The National Rifle Association has a guide that outlines what a safe construction of a range would look like. Ohio has explicitly adopted this book as the resource for constructing a range, but is the only state to have. One case where negligence law can come up and have a quite severe impact was a tragic case out of Michigan where there was a shooting range used for police training. This range allowed 2 children unsupervised on the range. One of them found a loaded firearm and accidentally shot and killed his friend. Negligence law came in and said it was negligent to allow you to have these children running free, and so we're going to impose liability on you for that. The second area is legislative solutions. Maine is one of about 1/4 of the states in the United States that have a statute saying that towns cannot impose noise ordinances against a range that was existing prior to the ordinance. This helps protect ranges from people moving into their area when they've been operating well for years and then claiming that they're a problem. Additionally, towns can use zoning and permit requirements to control where the ranges operate and require them to apply for a permit every year, which most towns in the state of Maine do, to ensure safe construction and to ensure that they're not causing issues. Finally, the Constitution of the United States came up. After the Supreme Court cases of Heller and McDonald, the Second Amendment protects an individual right of ownership of firearms outside of service with the militia. The Seventh Circuit took this one step further and said that the right to own firearms necessarily includes a right to obtain and maintain proficiency with firearms. Therefore, shooting ranges in the Seventh Circuit are constitutionally protected under the Second Amendment. But they are the only federal circuit to have done this. The Fourth Circuit has had the explicit opposite reaction, saying that some regulations are permitted and you are allowed to limit these shooting ranges. And the First Circuit and every other circuit has not come to a conclusion on this issue. If anyone has any questions about shooting ranges, the Second Amendment, or any of these firearm issues, I'd be more than happy to talk with you in the lobby after this talk. Thank you.